Mr. Lim Biow Chuan.
Mr. Deputy Speaker, like Mr. Murali, who spoke earlier before me, I declare my interests as a practicing lawyer. For many years, lawyers in Singapore are guided by the laws against maintenance and champerty. Section 107 of the Legal Profession Act provides for an express prohibition against a lawyer having an interest in the lawsuit of his client. Section 107 says a solicitor must not purchase or agree to purchase the interests or any part of the interests of his client or of any party in any suit, action, or other contentious proceeding brought or to be brought or maintained. Or B, enter into any agreement by which he is retained or employed to prosecute any suit or action or other contentious proceeding which stipulates for or contemplates payment only in the event of success in that suit, action, or proceeding. And Section 1073 provides that a solicitor is subject to the laws of maintenance and champerty like any other person. In Rule 18 of the Legal Profession Professional Conduct Rules, it was stressed that a legal practitioner or law practice must not enter into any negotiations with a client for an interest in the subject matter of litigation or for remuneration proportionate to the amount which may be recovered by the client in the proceedings. So the rationale for these rules is based on the conventional wisdom that the advocate and solicitor must maintain his independent and professional standing, unaffected by any personal interest in the outcome of a matter in order to act effectively in representing his client's interests. As recent as in 2013, the Court of 3 judges suspended a lawyer, Mr. Kurabalan, for 6 months for breaching Section 107 of the Legal Profession Act and Rule, at that time, 37 of the Professional Conduct Rules, because he entered into a champertous agreement with his client. In the decision by the Court of 3 judges, the court went through the reasons for the law against champerty. And at paragraph 40, the court said, maintenance is defined as officious intermeddling in litigation, and champerty is a particular form of maintenance where one party agrees to aid another to bring a claim on the basis that the person who gives the aid shall receive a share of what may be recovered in the action. So I acknowledge that quite a few countries have abolished the law against champerty, example, United Kingdom, Australia and Canada. I also acknowledge the explanations given by the Ministry of Law in its media release on 1st of November 2021, explaining the government's rationale for amending the Legal Profession Act to allow for the conditional fee agreement. One of the key principles which I agree with is that CFAs help enhance access to justice by providing business or individuals with additional funding to pursue meritorious claims which they may otherwise not pursue. Another advantage is that it levels the playing field for Singapore lawyers in areas such as international arbitration or SICC proceedings, where the counterparts in the other countries may have access to such types of funding. Nevertheless, I also wish to express my concern. The rationale for the rule against champerty and maintenance are still very applicable today, even if some countries have already abolished the law. One of the rules, as stated in Rule 4 of the Professional Conduct Rules, is the lawyer's paramount duty to the court as an officer of the court. And this duty takes precedence over the legal practitioner's duty to the legal practitioner's client. Let me say that again. A lawyer has a paramount duty to the court as an officer of the court, and this duty takes precedence over the lawyer's duty to his client. So may I ask the Minister, what are the safeguards to prevent a lawyer from subverting the cause of justice if he has a vested interest in the outcome of the legal proceedings? As Lord Denning observed in the 1962 judgment, the common law fears that the champertous maintainer might be tempted for his own personal gain to inflame the damages, to suppress evidence, or even to support witnesses. So currently, the amendments define prescribed proceedings to mean proceedings as prescribed in the regulations. However, later, if prescribed proceedings is extended to other forms of litigation in the future? Would it result in more litigation suits because of the personal stake of the lawyers in the outcome of the lawsuits? In 2008, 21 people were arrested in Hong Kong for championship, maintenance, and conspiracy. And these people were recovery agents helping accident victims on a no-win, no-fee basis. And one of the people arrested in Hong Kong was a lawyer. How would the police deal with an unscrupulous lawyer or his agents in Singapore who may decide to stake out hospitals to look out for victims injured in road accidents or industrial accidents? I believe there are complaints by insurance companies against lawyers or sometimes their agents who are seen as what we call ambulance chasers. These people are quick to ask the victims to sue in order to claim for more damages and legal costs. Would this group of people be able to circumvent the law by asking the accident victims to sign the CFA? Finally, third, may I ask the Minister who will protect the interests of the vulnerable client if the lawyer has an interest in the outcome of the suit? So for example, if a lawyer wishes to settle the case because his legal costs are protected, then that lawyer may then insist on a settlement, even though the client may disagree to the terms of settlement. In such a case, the interests of the client and the interests of the lawyer may no longer be the same. Finally, like Mr. Murali, who spoke before me, I'm concerned about the uplift fees. For uplift fees, would there be a prescribed range of uplift fees allowed? Under what circumstances would the uplift fee be subject to a charge for overcharging made against the lawyer? I hope the Minister can clarify my concerns because the Court does sometimes look to debates in Parliament to understand the intent of the law. Thank you, sir.